Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone. This is Tiffany Thomas, and I'm one of the lawyers here at SpringLaw. I'm here today with one of my colleagues, Matt Chapman. With it being 10:30 exactly, we're going to get started with our introductions. If you're one of our clients, you probably already know that we are an employment, labor, and contracts firm, and we're a fully virtual firm based here in Ontario. Matt and I are joining you today from a very snowy southwestern Ontario, but our entire firm is spread across Ontario. We do a webinar every third Wednesday of the month, and we cover different legal topics in each webinar. So if this is your first time here, welcome, but please come back next month on the third Wednesday of the month. Throughout any of our time today, feel free to ask questions through our chat function, and our team will send those questions over to Matt and I, and we're happy to answer them as we go along. We're always aiming to answer the questions, so we'll do our best on that front. And one more housekeeping note, there are slides in the handout tab if you want to grab those and follow along. I think there might have been a technical issue with our webinar platform this morning, so you may have to navigate over to our website to get those as well. So if you do have any questions about our firm and you want to learn more about us, or you're looking for some excellent resources on all of your burning questions about labor, employment, and contracts, you can visit us at springlaw.ca. We have an award-winning blog, a monthly newsletter, and lots of information about our subscription programs over on our website. And you're also going to find some information there on our brand new Boss Law Bootcamp, which really helps employers either implement or update your entire employment law infrastructure. It's a really innovative online platform for employers, and it helps you combine your do-it-yourself and some legal services. So as I mentioned, I'm here today with Matt Chapman. Matt has an incredible background in employment law, specifically in a lot of executive compensation work and litigation. I also have a background in employment law, and I'm also passionate about labor and human rights. Before we get into our legal content, I'm going to take a brief moment to acknowledge that we are on the land of many traditional nations, and that this territory is now home to many diverse nations, First Nations, Inuit, and Métis people. Now, we wouldn't be lawyers without a disclaimer. Gonna go over to our next slide, and you're going to see quite a lengthy legal disclaimer. The important information we want you to know is that this presentation today is, of course, only legal information. And as you will see with our content today, the law is typically very fact-specific, and as such, we are only providing information and not advice today. Here's our lovely legal disclaimer slide that we would welcome you to take a better look at following today's presentation. So with all of that important information said, let me talk to you a little bit about what we're going to be talking about today. So we're going to be taking you through today, first and foremost, what a working nomad is, but more importantly, some of the legal complexities that you need to be aware of before agreeing to enter into an agreement to let one of your employees go nomad. It's going to be a bit of an issue spotting exercise that we're going to walk you through today, and we're going to also help you think about some of the steps that you can take before entering into one of these agreements in terms of putting that important information into your contract or your policy. And we're going to finish off with some best practices on remote and hybrid work. So this webinar is really designed for those of you who are considering allowing your employees to travel to a foreign jurisdiction that are already working for your company, as well as those of you who have already decided to stay remote and hybrid and are just looking to pick up some more information on some of the best practices around those working arrangements. So with that said, I'm going to turn it over to Matt, who is going to walk you through what a working nomad is.
Thanks, Tiffany. So what is a working nomad? There are arguably two different types of situations in which this title can apply. So there are workers who don't currently live or work in the jurisdiction in which your company exists, but who want to work for your company. There are also workers who currently do live and work in your company's jurisdiction, but who want to work and live outside of that area. So for example, Tiffany, who's currently manning SpringLaw's London, Ontario office, might want to travel to another province or another country and continue her work for SpringLaw there. Based on today's weather, I'm going to assume that would probably preferably be somewhere warmer though. But anyway, this type of working nomad is the one that a growing number of our current clients are dealing with. And we're fielding more and more questions about the employment law issues and realities that arise for this type of worker. So what do you do if your employee wants to move? There's no denying the pandemic has rapidly normalized remote work. What the pandemic forced on many employers by necessity has now become the expectation for a great many employees. Over the course of the pandemic, many people seized the opportunity to move away from their more densely populated areas where their employers' facilities were located, and they now enjoy a commute time of approximately 0 minutes. And many have no desire to return to office work. We remain in a tight labor market, and employers who fail to offer remote working options will be attempting to hire from a shallower talent pool, and they risk losing their current talent to their competitors. There can be significant benefits to hiring remote workers, though. Many employers who do are reducing their commercial real estate costs. They arguably have happier employees, and they can find the right people for the roles they need to fill, no matter where they are. With SpringLaw, for example, we're able to hire lawyers and staff with the specific skill sets and experience that our clients require, without being restricted to a limited geographic region. So it's one thing if your employee wants to remotely work from another part of Ontario, but what do employers do if their employees want to work from another province or country or travel the world and work? What issues will you as an employer encounter? The answer to that, perhaps unsurprisingly, is extremely complex as far as the law goes. The possible risks are very fact-specific to the employee and the employer, as well as the jurisdictions in which the employee and the employer are going to operate from. So on that note, what's jurisdiction and why does it matter? In legal terms, jurisdiction refers to the type of case and the physical area over which a court has legal authority. So if you have an employee who works outside of Ontario, one of the potential risks that employers face is not having the certainty of what laws will apply to the employee and what courts will have authority to resolve issues between the employer and the employee if disputes occur. As I've said, the law in the area is very complex, but one potential risk that an employer faces is that the location in which an employee resides may end up having even friendlier employee side regulations than those we see in Canada. I'm sure some of our employer clients who are on the webinar might be shocked to hear that that's possible, considering how friendly employment law is to employees in Canada, but it's a real possibility. It's even possible that the laws of both jurisdictions, where the employer is located and where the employee is resident, might apply to confer benefits on an employee. So if your employee was hired in Ontario but now lives in another country, do they get Ontario public holidays? Do they get the holidays of the country they're resident in? Do they get both? If you're creating an employment contract or an agreement to allow nomadic work, you should consider including a clause that states that the laws of your jurisdiction govern the contract and that your jurisdiction is the proper forum for adjudication of any disputes. This is a helpful fact for employers to have, but it does not guarantee that any dispute between the company and the employer will be resolved in the jurisdiction outlined by the contract, or that the employment standards of the jurisdiction outlined in the contract will apply at all. An employer in Texas, for example, won't be able to get away with an at-will employment agreement for an employee who they know will be working full-time in Ontario. Employers should absolutely consult with an employment lawyer if they are considering a nomadic working arrangement for an employee, as a detailed jurisdictional analysis may be required. Employers will face other risks beyond jurisdiction, and I'll pass it back to you now, Tiffany, for an exploration of some of those.
Thanks, Matt. So yeah, let's assume that you're an employer and you've realized that your employee is moving to a different jurisdiction and you're concerned, or you now know that that employment legislation from that jurisdiction may apply. So what's your next step? So you're going to want to start by checking the governing jurisdiction's employment legislation to determine if it defines who it applies to. So we have a very interesting example of this here in Ontario, where Matt and I are located, because our Employment Standards Act actually sets out who the Act applies to. So you can see on the slide here that we have the definition from our Employment Standards Act here in Ontario. And what it says is that subject to subsections 2 to 5, the Employment Standards Act sets out who it applies to with respect to an employee and his or her or employer if, firstly and logically, the employee's work is to be performed in Ontario. So that takes care of all of us who are working for a company here in Ontario and who are also living, working here. But it also says that the employee's work is to be performed in Ontario and outside of Ontario, but the work performed outside of Ontario is a continuation of work to perform in Ontario. So that's a bit of a mouthful, of course, but what it's basically getting at is that if the work is to be performed in Ontario and outside of Ontario, and the work is a continuation of the work that occurred in Ontario, then the ESA would apply to that person. Now, I've left the part of the boring legal citation in there, which for your information notes that this was actually added to the ESA in 2000. Now, why is that interesting? Because obviously back in 2000, very few of us had any idea what COVID was or what it was going to do to our working landscape. And so I think that's important to note, because while we can say that, yes, this definition exists and it applies at this point, it is still a fairly unsettled area of the law. This is a new world we're living in. And so we're definitely going to have to keep our eyes on exactly how this is going to apply to remote employees, nomad employees, because it could apply differently, but this is what we know at this point. Probably likely it applied at first to those people like salespeople who worked a lot in Ontario and traveled for their work, even truck drivers who were doing the work that they were doing in Ontario and continuing it across other provinces or territories. Now, in Ontario, a recent Labour Relations Board decision clarified that for the Employment Standards Act to apply, there actually has to be some back and forth between Ontario and the host location, as well as a clear and definite date and place of return for the employee. So these are all things that are necessary. So again, there has to be some back and forth between Ontario and the host location, and there also has to be a clear and definite date and place of return for the employee. So, an employee who's stamping a one-way ticket with no intention of coming back to Ontario, we can probably likely assume that this isn't going to apply. And if they're leaving somewhere on a permanent basis, they're leaving Ontario, they have no intention coming back, and they're not doing any kind of back and forth, you're going to have to consider whether the Employment Standards Act is going to apply under those circumstances. So a remote work arrangement that would merely provide for the possibility of a return to Ontario will likely not suffice to mean that the ESA will apply. There are some common questions that Ontario courts ask to determine if the ESA will apply to an employee who is working abroad. Here are some of those questions. Whether the employer company resides in Ontario, whether the employer company carries out business in Ontario, whether the matter at issue, whether it's a termination, for example, took place in Ontario, and whether the contract related to a dispute was made in Ontario. But again, keep in mind, even with some of those things in mind, it's still possible that they're not going to find that the Employment Standards Act in Ontario applies. So if that governing employment legislation in the company's jurisdiction, so we can imagine your company is located in Ontario, and if it's not found to be applicable to the employment standards with that employee, then the employee may successfully bring an action in another jurisdiction under their employment standards. So again, speaking to the risk here, if we find that the Ontario ESA does not apply to an employee who was formerly employed in Ontario, that means that they can can now successfully bring an action in another jurisdiction. And where this could be especially risky if they're moving to an area that is especially and even more friendlier to employees than here in Ontario. So if they're moving to Texas, you might not be as stressed, whereas if they're moving to somewhere in the EU, you may have something to worry about in terms of the law that could be applied to their dispute. The precise answer in these situations are really going to depend on the legislation of the worker's home province, as well as the particular circumstances of the worker's employment. There are some other issues that are going to be potentially addressed by the employment standards legislation that you're going to want to check out while you're looking at that legislation. There might be instances in which it defines the currency that has to be paid to the employee. So this happens, for example, here in Canada in BC, which actually their employment standards legislation requires employers to pay all wages in Canadian currency. And there might also be other helpful information in the jurisdiction's employment legislation that you're going to want to check as well, including references to tax, health and safety potentially, as well as you're going to want to consider whether that person can hold themselves out as the sort of professional they are in that jurisdiction. So this could apply, for example, to accountants, people like Matt and I who move to another jurisdiction. You're going to want to question, if you're relying on that person's professional designation, whether they can hold themselves out as that while they live in that new territory, province, or country. Again, this is very likely to be a continuing area of development in the law. And, just again, like we look at the Ontario Employment Standards Act, which has this definition from 2000, very likely that we're going to see further developments in this area. So, be keeping an eye out if you can, be checking out law firm websites like ours for these developments. So how can you preemptively address some of these issues? So for new hires who are going to be permitted to work as nomads, many issues can be addressed in the contract. These same issues can be addressed for existing employees through a remote worker policy or agreement, which you could ask them to sign off on. So here are some things that you might want to address in the contract or policy before agreeing to allow one of your employees to go nomad. So you're going to want to address the particular location that they're going to be operating in and make it clear that this has to be given through express permission of the employer. So you're going to want to determine if you're okay with a nomad, truly being a nomad, moving around place to place. Let's say, we all are living out our dream of living in a van and traveling province to province. Are you okay with this? Or do you want them to stay in a specific province? And if so, you're going to want to potentially address that in your contract by making it clear that if they're moving province to province, they need permission, or if they're going to move from one location to the next, you're also asking them to seek permission on that as well. The employment contract should also specify whether the remote working arrangement will be permanent or temporary, or whether the worker will have a hybrid working arrangement whereby the worker can work, both in office, they're welcome to travel. These are all things that I think just help demystify this whole process for both the employee and employer. You're going to want to outline in your contract or policy that the location must comply with applicable health and safety laws. You want to be concerned about their safety. And again, you're going to want to approve it. What you want to be careful of is if the remote work becomes part of the essential term of employment, either through the contract or through the actual agreement, or whether it just be through the work arrangement, you want to be aware that any kind of unilateral changes, so any decisions you make on the basis of being the employer alone, can carry the risk of constructive dismissal claims. You might be able to reduce this risk by explicitly retaining the right to determine the place of work and clearly setting out the terms. But you have to be really careful with this, because if you know that you're hiring an employee, let's say, who lives in Alberta, you're going to have a really tough time legally compelling them to come live here in Ontario because you want to keep a closer eye on it. So I wouldn't say to expect that. But if you're in a situation where you've already hired an employee, they've been long-term term with you. Now they're asking to move around. You may want to retain the right in your contract to say, this is temporary, for example. It's not, and if it's not working out, we're going to ask you to come back to Ontario. Another thing is that if you're considering permitting employees to move abroad who currently work from Canada, you can make it temporary, as I said. But ultimately, your biggest concern is if you know that they're moving to another jurisdiction or they already live there and you're hiring them and that you know that they're going to live in that jurisdiction, you really want to harmonize it with the legislation from that area. So let's take a very easy example. You're deciding to hire an employee who you know is going to live and work in Alberta. You want to check out the Alberta employment standards legislation and build the contract around that legislation, as opposed to trying to impose Ontario terms and expectations, let's say for termination, to somebody who's going to be living and working in Alberta. Just a few practical tips. Your work hours and availability might change based on time zones, so you want to address this up front. If you're expecting your employee to be available between 9 and 5 Toronto time, how does that work for them if they're in a different time zone? It also is going to depend on the basis of availability. Employers like to be able to get in touch with their employees, and so you're going to want to sort out how that's all going to work. You may want to address who is paying for relocation and commuting costs, who is providing equipment, and how is it going to be returned upon separation from the company. So if they quit or are terminated, how are you getting all of this equipment back? Any expectations you have regarding the actual working location. Are you okay with them working day to day from a cafe, or do you want them to only be using secure internet at home in their home office? You're going to want to consider insurance coverage, as well as whether your employer benefits will apply to these individuals who are traveling, especially if it's on a long-term basis. I'm going to turn it over to Matt now for some matters that employment lawyers cannot advise on.
Thanks. So there's two main types of questions that we as employment lawyers frequently get asked about that we can't fully advise on, but that employers should be considerate of when considering whether they're going to employ nomadic workers. The first are the potential tax implications. Employment income is taxed in most jurisdictions. There's a few out there that are lucky enough not to have to pay employment taxes. But the employer can be held responsible if they fail to make proper deductions and withholdings here in Ontario. It's not uncommon for us to get asked questions that are even more tax specific than that, though. We're not tax specialists and we're not accountants, but employers should seek advice about potential tax obligations that they may incur for their nomad employees, because it could be very jurisdiction specific. There can also be possible immigration related issues. Who's going to be responsible if visa issues arise? Are there potential healthcare benefit issues between the employer's provided healthcare plan and where the nomadic worker ends up? After a certain point, there's OHIP related issues if someone's out of the country for a certain period of time. So at a certain point, it may be something that an employer may want to engage an immigration lawyer on to get some worthwhile advice. On the immigration front, some countries are taking some very interesting approaches to nomadic workers, though, and I'll let Tiffany tell you a little bit about a real world example on that front.
Thanks, Matt. So you might have already heard about this or maybe done some research on your own about taking part in this. Don't blame you if so. This is just one example, and this is Costa Rica's digital nomad visa. And basically, this country has made it a lot easier for employees to potentially move to Costa Rica for a period of time and to work from there. So how they're working their program is they're inviting international residents to work remotely. It essentially extends a 90-day tourist visa to a full year with the option to renew for an additional year. So it's possible that your employee could be there for 2 full years. The employee is exempt from income tax in that country. They can immediately open up a bank account, which makes it a lot easier for them to live there, of course, and they get a validation of their home country's driver's license so that they can drive around while there. And it's pretty lax in terms of expectations from what I understand from the Costa Rican website. Just a little bit of expectation around how much money you're making per month. 3,000 US for those of us going without kids, and 4,000 if they do have dependents. It has to be a stable income. And when I was looking into this, they really just are encouraging people to apply and see what happens. It's a short turnaround, and so I think they're hoping people will apply, and if something goes wrong, they can fix that and help them walk them through that process. And it was just yesterday that I heard on the news that Italy is actually going to be introducing a very similar program, or is just about to, specifically to youth. But just for those of you who are wondering, it's under 35 is considered a youth. So great news all around there. So we do have a question, and the question is, so it sounds like a US-based company with employees in Ontario, for example, may not necessarily be subject to the ESA. So this is actually something that we deal with quite frequently at SpringLaw, and we refer to it as Canadianizing a US-based contract. So in this case, what we would typically say, again, very fact specific, but typically if you're a US-based company, you're looking to hire and onboard an employee who's going to be living and working in Ontario, we would actually say that the ESA is likely to apply to them, because if they're living and working here, it's going to be one of those jurisdictional matters likely to apply to them. So you do need to be cautious. This is something we do a lot, as I mentioned. And typically, it's quite a big jump, because from our US-based employers, we're looking at things like at-will employment contracts, very different to here in Ontario. Matt, do you have anything to add to that? Okay. So we're going to move on to topic 2, which is best practices for remote and hybrid work. So we are, of course, a little bit biased as a fully virtual firm, but it's working so well for us. We love working from home. We, of course, go in person to things like court mediations where necessary, but day to day, we all are fully virtual. We absolutely love it. And these are just some best practices, takeaways for you today that we think you should be aware of based on our experience as employment lawyers. So for us, we find that workplaces really thrive when a clear framework is set out. So even if the employees don't love every aspect of the policy, the more clear the framework it is, the better the workplace seems to do. We just see far more disputes based on broken telephone, misunderstandings, and assumptions than disagreements about a clear rule in the workplace. So we would recommend right off the bat that setting out clear written parameters and expectations around where and when people should work will eliminate a lot of the disputes that you're potentially going to have to face. And I could talk about clear remote work policies all day long. I like writing them. There's plenty of basics that need to go into these policies. But again, the most important part of them is to get a clear written framework out there. In the interest of time, I will not keep going on about this first best practice, but I will turn to our next best practice, which is to make these eligibility decisions fairly. And what I mean there is, if this is a privilege that you're going to extend to only some of your workforce, you want to make sure that all decisions, like every decision you make in the workforce, is done fairly and in a non-discriminatory way. So you want to be keeping that in mind. You also just want to be keeping in mind on a practical level that in some cases, when you have a two-class system where only some employees are allowed to work remotely and some are not, you're going to potentially experience a rub amongst your employees, and you want to keep an eye on that as much as possible and try to, where you can, figure out ways to really allow people to go remotely. So the easiest example of this is, we often see employers who have to have an employee in the office day to day because they accept mail, for example. If it's going to create a massive rub amongst those employees who can't work virtually versus those of us that can, you might want to consider some easy ways. Go virtual, move your mail to the cloud, have them come in a couple of times a week, but not every day. Just some practical things that you can do to help reduce any kind of potential animosity that could exist between these two groups of employees. Something that I absolutely have to brag about with SpringLaw and why I've put this on the slide is we have a lot of great workflows here. What I think this has done as an employee who's joined SpringLaw in the last year, we don't always necessarily have that day-to-day pass you in the office, it's super easy to knock on your door and say, hey, Matt, I forgot how to do X, Y, and Z. Would you mind reminding me? So these workflows really demystify workplace procedures and introduce ways of doing things that employees might otherwise have learned to do them in an in-person environment. I think this can all be better supported through, things like Slack channels, employee chit chat, just to, again, support these workflows and make it easy for people to know how to get things done without having that ability to just walk down the hallway and ask. So just having these clear internal communications and strategies and workflows, it's going to save you some time, and it's going to make everything a little bit clearer to your employees.
And number 4 on our list involves being mindful of occupational health and safety obligations. Some jurisdictions may be more strict about how those apply to a home office, so employers should treat home offices as extensions of their dedicated commercial spaces. Employees in Ontario who are injured while working in a designated home workspace while performing a work-related task can make WSIB claims and be eligible for those benefits. With this in mind, employers should take all reasonable precautions to ensure that an employee's workplace is free of hazards. Employers need to balance privacy concerns when you're dealing with somebody's private home. But a best practice would be to start with a employee self-assessment of potential hazards in their workspace, so the employer can provide a form and provide the details of what they want reviewed, and then they can work with the employee to make sure that the home office is a safe space for them. Our last best practice tip involves analyzing how your other employment policies will apply to your remote workers, and to ensure that there's no conflict between older policies you may have in place and any new remote work policy you may wish to institute. Policy review and updates are work that we complete on a regular basis, and it's something that we're more than happy to help you with. We're running short on time here, so for takeaways, I'll just jump into this quickly. While these issues are complex, remote work is not likely going away anytime soon, and employers will always be on better footing if they review the remote work risks with their employment lawyer before those risks become tangible and potentially costly problems. Nomadic workers, especially those who work in other provinces and countries, will present unique and fact-specific challenges for employers. Engage in SpringLaw to help issue spot potential jurisdictional issues and risks, and prepare agreements that can minimize those risks can save you plenty of headaches and money in the long run. It looks like we've just exceeded our time, so I think we'll probably leave it here for today. Thank you, Tiffany, and thank you, Jessica Raposo, our operations manager, for all your work in bringing this edition of our Spring Forward webinar together. And thank you to all of those of you who've attended today. I think if there's a couple extra questions, please do reach out to us. We'd be happy to go over some of these points with you. Enjoy the rest of your day.
Thanks, Matt.